On the last day of the monsoon session of the Parliament, Home Minister Amit Shah tabled 3 bills to replace the British-era Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act. While tabling the bills, the Home Minister said he would repeal the section dealing with the Sedition Law.
मान्यवर, राजद्रोह पर कि अंग्रेजों ने अपने शासन को बचाने के लिए एक कानून बना था, मैं इस सदन को कहना चाहता हूं, एक ऐतिहासिक निर्णय इस सरकार ने किया है। राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं, कंप्लीटली। यहां लोकतंत्र है, सबको बोलने का अधिकार है। राजद्रोह को हम कंप्लीटली रिपील कर रहे हैं, मान्यवर।
However, upon closer inspection, one can see a new clause that not just retains the spirit of the sedition law but also has a broader definition of the offence. And that clause is section 150 of the Bharatiya Nyay Sanhita. So let's dive in to know what the old law and the new bill says. But before that, please don't forget to like and share this video, and please subscribe to Moneycontrol YouTube channel. If we look at the sedition law that comes under section 124A of the Indian Penal Code, it says, whoever by words either spoken or written, or by signs or by visible representation, or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend up to 3 years, to which fine may be added, or with fine. On the other hand, section 150 of the Bharatiya Nyay Sanhita says, whoever purposely or knowingly by words either spoken or written, or by signs or by visible representation, or by electronic communication, or by use of financial means, or otherwise excites or attempts to excite succession or armed rebellion or subversive activities, or encourages feeling of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life, or with imprisonment which may extend to 7 years, and shall also be liable to fine. Now both sections have similarities and differences. One of the basic differences is the term of punishment. Imprisonment of life or a jail term of up to 3 years is mentioned in section 124A of the IPC, whereas section 150 of the BNS says the punishment of life imprisonment or a jail term of up to 7 years. Now apart from the punishment term, the new section also has new words included in it. To understand those, we spoke to Supreme Court Advocate Shadan Farasat, who first pointed out the similarities and differences between the two sections.
So the new section, which is 150 of what I would call the new IPC, is really speaking, in a way it's similar, in a way it's different. It's similar in the sense that the broad rubric under which this provision is there of a similar kind which sedition was there. So which is to what it captures within it is not an actual action. It captures speech or a written statement of some kind. So it's not as if some actual action as such is being sought to be penalized. What is being caught, just like in sedition, is a speech or something written and nothing more. So to that extent, it's quite similar. The difference, of course, is that it adds a qualification, purposefully or knowingly. Now, that by itself does not mean much, because sedition, the way it had been interpreted by courts, you can take it that these qualifications were already judicially, in that sense, already added. It was not, although the section didn't have it, 124A of IPC didn't have it, judicially they had been, in that sense, already included in the sections.
Next, in contrast to section 124A of the IPC, section 150 specifies 4 distinct offences that could lead to charges against an accused individual. These offences include engaging in succession, participating in armed rebellion, undertaking subversive activities, or encouraging feelings of separatist movements. However, while doing so, section 150 does not define subversive activities.
In a penal statute, when you are making a penal statute, when you are effectively penalizing a certain action, and more so, it is when it's not actual physical action, but it's really a speech which you are targeting or penalizing, then you have to be really speaking very, very careful in what you are penalizing. It has to be tailored as narrowly as possible, if at all necessary. In my view, there was not necessity at all. But if at all necessary, it has to be tailored with very clear-cut definitions and the narrowest definitions possible. What this does is subversive activities. There can be a dictionary meaning. There can be a legal meaning, a regular English dictionary meaning. There can be a legal meaning to it. There can be, a meaning which will be there in some other statutes. For instance, I understand it's been defined in some West Bengal Act, in terms of it, and there it's been defined very broadly. Now, what meaning will eventually be ascribed to this? We don't know. So anything which is so broad, open-ended, vague, undefined, obviously is problematic for a penal statute, especially when you are penalizing free speech.
Along with words either spoken or written or by signs, visible representation, the new bill expands the definition of the offence by including terms like electronic communication and use of financial means.
Insofar as electronic communication, basically, my sense is either spoken or written. The word written would have broadly covered that in that sense earlier. Now, because this act is new and you have for the last 15-20 years electronic communication, so it's expressly mentioning it. So I don't have a grudge with that so much. Really speaking, the section as a whole is problematic, whether you include written electronic communication or not. Just writing something by itself to penalize it is a problem in these kind of situations. And use of financial means, I think, is in line with this government's understanding of anything. I think that's really a space open for misuse again. That anything which is counter the government, it can even be counter narrative. It can be regular political opposition activity. Now, those kind of things can also be brought in, something in terms of being captured by this section. So, funding a political party which is opposing the government, can it be covered in this? Normally, one would think no, but a government which wants to misuse it can, in a certain kind of a case, try and make out a case even against something like that. So, all of these kind of things, you never know what the scope is. And it's just a way of broadening that scope, and then that leaves the discretion with the government.
The government may not have explicitly used the term sedition, but Section 150 looks to have retained all the ingredients of the British-era colonial law. The new bill makes no attempt to list activities that could be seen as a threat to countries' sovereignty or unity and integrity.
This is really a sedition. It's old wine, same kind of thing in a different kind of a structure. So old wine in a new bottle is what they have done. They may call it whatever, but really speaking, all those criticisms which were available to sedition are equally applicable to this, in some context, possibly with a little more force.
Home Minister Amit Shah has sent the bills to the Parliamentary Standing Committee for further pursuit. It will be interesting to see what happens to these bills. Will it pass the floor easily or will it face controversies?